So once again, welcome to everybody on our webinar today, Data Protection in the UK and its Crown Dependencies and British Overseas Territories. We were talking with our friends at Appleby Global a few weeks ago and thought it would be a good idea to do a compare and contrast between the General Data Protection Regulation, pan-EU, what we are doing in the UK, and then what is happening in our Crown dependencies like the Isle of Man and Jersey and Guernsey, and some of our British overseas territories like the Caymans, BVI and Bermuda. So I'm delighted to say we've got a number of colleagues from Appleby dialing in from different parts of the world, and I'm hoping that the technology will work. And just before we get started, a few admin points. The webinar will be recorded and will be available for download a few days after we finish the webinar today. You have a questions box, so do by all means send in questions, and I will either address them to our panelists if they are immediately relevant, or I will keep them towards the end of the session today, and then we'll have a Q&A. For my colleagues from Appleby, if you can keep on mute until I ask you to present, and by all means tell us when you are presenting when you would like to move to the next slide. So by way of introduction, I think many of you will know me. I'm a partner here in the commercial IP/IT team, and frankly do really nothing but, and have done nothing but, data protection for many years. And that's frankly enough about me. So I'm delighted to now introduce Claire Milne. Claire is a partner in Appleby in the Isle of Man, and as you can see, she has many years experience in a range of IP, science and tech related work, but is focusing a lot of her time now, like many of us, are on data protection related issues. And we're then joined by Richard Sheldon, who is Counsel of Appleby in Guernsey, and will be looking at the Channel Islands in terms of data protection issues, where he is the lead advisor for the firm. Then we have got Peter Colegate, who is dialing in from a warmer part of the world than we are currently in. Peter is a senior associate out in the Cayman's BVI Bermuda part of the world, and he's going to particularly look at that area in terms of their implementation of data protection laws. And then finally, Katherine Johnson, who's an associate in Appleby, will be specifically looking at the Isle of Man. Without further ado, in terms of the introductions, what are we going to cover today? Well, as I said at the beginning, GDPR at a high level, then where we are with the UK Data Protection Bill, to which there's just been some new changes today. Then look at the Isle of Man, Jersey and Guernsey, the Cayman Islands, Bermuda and BVI. That's not all of the entities that we might look at that have a connection with the UK, but I think there's enough going on there that makes it very interesting for us to realise it's not all about GDPR. But talking about GDPR, and I'm sure I'm telling you what you already know, because I think there isn't an hour goes by that there isn't something about GDPR. It does widen the definition of personal data, particularly sensitive or special categories of data. Personal data does now include things which we've always wondered about, like IP or internet protocol addresses, but in terms of the special categories, we now have under GDPR genetic and biometric data as a particular category. And GDPR also focuses, at least in terms of information service providers, on children. And we are finding that not every jurisdiction is coming up with the same age of when is a child and when is a child a teenager. But again, more of that in due course. GDPR for the first time says that the law applies to both controllers and processors or third-party vendors that are managing personal data, which is new. GDPR uses keywords like transparency and accountability, not words that we saw in the Data Protection Directive, although words that we've seen in other international conventions like the OECD guidelines and Convention 108, which is a topic in itself. There's also the concept of the one-stop shop, so that there will only be one lead supervisory authority that you will need to deal with as a controller or processor in the EU. Although we are finding that each EU member state, as they develop law, are using the derogations and the nuances available at a local level. So the thought that the regulation is one rule in 28 member states is not exactly what is happening in the real world. And of course, we will hear in terms of other panelists that, again, not everything is the same in our dependencies and overseas territories. For the first time, there is the mandatory role of the data protection officer, which does raise a challenge for many businesses. There are new obligations on controller and processor in terms of their contractual duties, and particularly where data is being transferred overseas. There is also the concepts of privacy by default or privacy by design and data protection impact assessments, which we didn't used to have. There's a widening of the available mechanisms for international data transfers so that it's not just about model clauses or standard contractual clauses, binding corporate rules, privacy shield, and so on, but we now have the concepts of geographical or sectoral codes of conduct in terms of managing transfers. And then, of course, everybody keeps hearing about the 4% of global annual revenues type fines, and it's not, of course, entirely like that, and I think it will only be in some of the most egregious cases within the EU that we may see people being hit with something that heads towards a 4% of global annual turnover or revenues fine. And my final point, which is not on the slide here, is that, of course, GDPR is extraterritorial in that it applies to controllers and processors outside the EU that are offering goods and services into the EU or monitoring data subjects insofar as that monitoring occurs in the EU. So where we have non-EU countries, they will be caught by GDPR in many cases. And of course, in terms of talking about the UK, whilst we are currently in the EU, it won't be very long before we are Brexited and not in the EU, and then we'll be the same as everybody else. And it was partly that shift that made me think this might be an interesting topic for us to go through. I wanted to spend, before I get to the more important speakers of today, a few seconds or minutes on the UK. So we have a draft data protection bill, which broadly implements GDPR standards across all general data processing. It's intended to provide clarity on definitions used in GDPR in our UK context. There are parts of the bill which are very focused to ensure that sensitive health data, social care, and education data can continue to be processed to ensure continued confidentiality in our health and safeguarding situations. There are provisions to provide appropriate restrictions to rights to access and delete data, to enable for national security or other public policy justified purposes for that data to be not accessed and not erased. We have set the age of a child at 13, below which parental consent is required, and above which parental consent is not required in terms of online information society services. There's additional powers for the Information Commissioner, our regulator, and moving to the next slide, indeed the regulator has recently set some registration charges for controllers, even though registration with the regulator disappears. You will, from April of this year, have a 3-tier registration system if you are a processor of personal data. There are sections in our UK bill around processing in relation to criminal justice, investigations and so on, and also provisions around the unfettered or unhindered flow of data for law enforcement purposes. Intelligence services have their own separate section of the bill. The ICO has the right to fine those eye-watering fines. Power for the ICO to bring criminal proceedings where a controller or processor seeks to alter records. And as at today, the 14th of March, there is a further amendment introduced to our bill, which is specifically covering the processing necessary to protect children and vulnerable adults from neglect or physical or mental harm, where, for example, it may be a reasonable disclosure of information by a controller if it is for the protection of somebody who is a child or maybe a vulnerable adult. And that looks to me an extremely positive addition. But of course, this is still a bill in the UK. It's still got some way to go. And I'm sure that this is not the end of what is going on. In terms of can we be more innovative in the terms of our UK law and perhaps anticipate Brexit and make ourselves a more exciting entrepreneurial jurisdiction for digital businesses to move to? I think the challenge is that if we drift away from the principles of GDPR, we simply will not be seen as an adequate jurisdiction for the purposes of international data transfers with or from the EU. Therefore, we will have to play by the same rules whilst we're in the EU and when we're not in the EU. And that is a not dissimilar principle that has driven what is happening in some of the dependencies and so on. And that's a good segue at this point for me to say, I'm going to hand over to you, Claire, and then Katherine to take us through what's happening in the Crown dependencies and particularly Isle of Man.
Thank you, Robert. Yeah, I mean, you're quite right. The whole issue of adequacy and the requirement to obtain an adequacy finding is something that the Crown dependencies, each Crown dependency has had to, or each part of the Crown dependency has had to go through. And just by way of background, when we talk about the Crown dependencies, what we're talking about is the Isle of Man, Jersey and Guernsey. Each of those jurisdictions is it has a separate legal system, has a separate constitutional relationship with the United Kingdom, and also has a separate constitutional relationship with the EU, but each does have its own adequacy decision. Each one of those jurisdictions is self-governing, none form part of the United Kingdom or the EU, and each has its own legislative assembly. And to be honest, the constitutional relationship of each with the United Kingdom is quite complicated, as is its relationship with the EU. However, the Queen is the head of state in each territory, and the UK is ultimately responsible for each territory's good governance and security. As a matter of principle, UK Acts of Parliament do not apply generally without the consent of each jurisdiction, and if that consent is granted, is done by way of order in Council. In relation to the EU, each jurisdiction's relationship with the EU is set out in what's called Protocol 3 to the UK's Treaty of Accession, and again, that is different for each jurisdiction. In the Isle of Man's case, Protocol 3 allows for free movement of industrial and agricultural goods, but not free movement of services or of people. And unlike the Channel Islands, the Isle of Man is inside the EU VAT area. Now, even though none of those jurisdictions are part of the EU, we can choose to implement parts of EU law if we decide to do so. And in the Isle of Man, that's under the terms of the European Communities Isle of Man Act 1973, which is partly the route that the Isle of Man has chosen to go down in relation to GDPR, which is something that Katherine, my colleague Katherine Johnson, will talk about in a minute or so. As each is not part of the EU, we each have our own domestic legislation in relation to data protection, and each has had to go through the process of obtaining its own adequacy decision. In the case of the Isle of Man, that adequacy decision was granted in 2004. For Jersey, it was 2008, and for Guernsey, it was 2003. The Isle of Man's data protection legislation at the moment is the Data Protection Act 2002, which, to be honest, is based very much on the UK's 98 Act. In fact, is pretty much word for word the same. The positive of that is that it's allowed us, from an advisor's perspective, to ensure that there's a degree of consistency, I think, between the advice that we would give in the Isle of Man and the advice that's given by UK lawyers. It's also helped in relation to if there is a lack of guidance in the Isle of Man, then we've been able to look to the UK Information Commissioner for guidance. That, however, as Katherine will talk about, is something we probably can't rely on going forward because of the route that we have chosen to go down in relation to implementing the GDPR. The Isle of Man has its own, as I said, its own data protection legislation. We have our own data protection supervisor, who since 2015 has also dealt with freedom of information legislation, and since that date has been referred to as the Isle of Man Information Commissioner. As I said, the Isle of Man is not part of the EU, and therefore EU directives and regulations, other than very narrowly in relation to matters that fall under Protocol 3, do not automatically apply in the Isle of Man. And because of that, as I said, we can implement our own domestic legislation in certain areas, and data protection is one of them. And that's the route that we've decided to go down in relation to the GDPR. And to deal with that specific aspect, I'll now pass over to Katherine to talk about that.
Thanks very much, Claire. So why is the Isle of Man implementing GDPR? As Robert mentioned, GDPR has extraterritorial effect. So many businesses in the Isle of Man have dealings with the EU and would need to comply in any event. And as Claire mentioned, we've got an adequacy status, so we would need to adopt GDPR compliant legislation in order to retain that adequacy status in the long run. Rather than closely following the UK's bill, as was done previously, the Manx approach has been to adopt a short framework bill to enable the implementation of GDPR and the Law Enforcement Directive, or LED, through secondary legislation. We understand that government's original intention was for there to be no primary legislation at all, but to use the Islands European Communities Act 1973 to give effect to GDPR as a European instrument. However, initial feedback was very negative about having no data protection primary legislation. The government has taken this on board, but the data protection bill is very short. It is just 7 clauses long, most of which are about interpretation, and it is an enabling act. The real detail is set out in a series of orders and regulations. So those will be the data protection application of GDPR order, the data protection application of LED order, and the GDPR and LED implementing regulations. There's a real feel that this legislation has been rushed. It was criticised in Tynwald, the Isle of Man's Parliament, as being lastminute.com. A nice quote. Rather bizarrely, the bill's been through the lower house of the Isle of Man's Parliament, whilst the suite of legislation is still up for consultation and is now making its way to the upper house. But the feedback from the consultation, which closed on the 5th of March, quite how that will be addressed is unclear. So what's in the secondary legislation? The data protection application of GDPR order applies GDPR into Isle of Man law pretty much word for word, save for amendments such as substituting the island where it says member state. If you see it, it is just the GDPR with a few scores out and new words put in. The GDPR and LED implementing regulations are what puts the meat on the bone and set out Isle of Man specific provisions. So it's in those regulations that we have that the age of consent in the Isle of Man is 13, just like the UK. But some of those specific Isle of Man provisions are things like matters which would constitute substantial public interest grounds for processing special category or sensitive personal data. This includes processing health data of certain relatives for an applicant of life assurance, which recognises the Isle of Man's successful life assurance sector. There are, however, some less helpful quirks set out in these regulations, such as requiring the island's Information Commissioner's consent to transfers of personal data to third countries, so outside of the EEA, without adequacy status, unless certain conditions apply. Whether this rather cumbersome requirement makes it through the legislation when it's in its final form, we wait to see. The regulations also retain an annual notification requirement. There's a rather frustrating sense of limbo at the moment, given that, as with many other jurisdictions, the granular detail will be set out in guidance and codes of practice, which will be Isle of Man specific. Whilst the guidance and decisions of the Commission's Article 29 Working Party will be relevant, as Claire mentioned, we'll no longer be able to rely on guidance issued by the UK ICO, given that differing approaches in applying legislation in the Isle of Man and the slightly quirks of our regulations. The regulations provide for the Information Commissioner saying that he must prepare codes of practice on data sharing and must prepare codes of practice on direct marketing. But this is currently an office of 3 people, so quite where the resource for creating all these codes of practice and guidance will come from and giving consent to these transfers and so on, we wait to see whether they will be given additional resource. The argument in favour of setting out these vital rights of personal data and serious obligations on data controllers and processors in secondary legislation is that these regulations can be easily amended without having to go through the sort of whole procedure of going through Parliament. This does not really protect a data subject's rights. Will this diminish the level of scrutiny that's given to any change if it's only seen as secondary legislation rather than a full act? We do wonder why other jurisdictions haven't taken this approach if it is the right approach. That said, there does appear to be changes further down the line. This looks like an interim way of implementing GDPR and the LED. The Council of Ministers have said that there's an additional data protection bill inside their legislative programme, saying that they will revisit this in coming years to see whether we can have an all-encompassing piece of information legislation, which would not be some sort of consolidation approach, but rather looking at this again with 2 or 3 years experience of how it's working to see whether we can put together a perfect piece for the Manx context. So GDPR is at least being implemented in the Isle of Man, but there seems to be a plan to see how things go, give businesses a bedding in period, just see what additional requirements that they have to deal with, and then the legislators will learn what needs to change from this practical experience and produce a carefully crafted, bespoke piece of legislation further down the line. That's the promise anyway, and of course the cynic would ask why we can't just have this from the outset. While the Manx approach to adopting GDPR may be unusual in this respect, by applying GDPR word for word, it would seem difficult to argue that against the Isle of Man maintaining its adequacy status. Any new bill would need to consider this, and we'll be watching with interest to see how other jurisdictions who have introduced their own bespoke laws get on when the Commission come to review their adequacy status. Being able to change the legislation without going through the full legislative process may be handy to address concerns raised in other jurisdictions or any case law that comes out in the future. So that's what we're doing in the Isle of Man. I'm now going to hand on to Richard, who will discuss how GDPR is being implemented in Jersey and Guernsey.
Thank you, Katherine. I think it's probably useful to, again, set a little bit of context, as my colleagues have done, in terms of what's happened historically in the Channel Islands, because actually we've had a very similar approach of simply adopting the UK's 1998 Act almost word for word again within both Guernsey and Jersey. And because of that, and because between the two islands, businesses so often have branches in both locations, we've actually enjoyed the benefit of having a joint Channel Islands Commissioner. Whilst they both have separate statutory powers in both islands, it was the same lead regulator, an individual called Emma Martins. Now, unfortunately, and this is locally quite a major headache for a lot of businesses, Guernsey and Jersey have taken quite differing approaches to the implementation of GDPR. And what that has caused is a split in the joint commissioner. So we are no longer going to be having essentially a single regulator pan-island. It's very much a retrograde step for the Channel Islands. So we will have Emma Martins, who's agreed to become the Guernsey Commissioner. However, Jersey currently has a vacancy, if you can imagine, of all things, a matter of months before implementation date. They still have not yet announced who the new commissioner has been. And this has been a running issue in the island now for a couple of months, where it's been known that Emma Martins was moving to Guernsey. So we are having, particularly in Jersey, some real challenges around the future of regulation. Now, if I touch on perhaps some of the differences between the two islands as to how they've gone about implementing, perhaps that might illustrate quite nicely the sort of approach that the two islands have taken. So Jersey very much has adopted not quite a literal interpretation to the extent that the Isle of Man has, but a very pure interpretation of GDPR, and has been very, very strict in its following of the language. Whereas Guernsey, I think, has perhaps, in an effort to make the legislation perhaps slightly more user-friendly, has made a few subtle tweaks to the legislation. I mean, one of them, probably the most high profile of those, has been some changes around the language of what constitutes consent. Nothing major, and I think the interpretation of it is likely very much to follow the European model, but there's just a few words here and there. Another bugbear in terms of how they've implemented, and this again will create problems for businesses, is something as basic as a timescale for responding to subject access requests. In Jersey, there will be 4 weeks to respond to a subject access request. In Guernsey, it's going to be a month. Now, if you put that in the context of most businesses here that do operate pan-island, to have those sorts of inconsistencies between the islands is quite a headache. Another classic has been that Guernsey has decided to take the concept of accountability and add it on as an extra principle alongside all the other standard data protection principles as set out in GDPR. So there are going to be, I think, some interesting conversations down the line between Guernsey and the European Commission about why they've adopted this approach. But this has definitely, I think, led to some real local challenges on the front of implementation, because we've got a real mix of businesses and entities in this part of the world. So a lot of businesses here, if I take, for example, all the major banks have branches in this part of the world. And what they're seeking to do is having their policies and their new DP clauses drafted by a HQ in London with a massive project team, and they're trying to implement the UK standard into the Channel Islands now, and they are coming up with, certainly I deal with lots of the local in-house counsel, and they are coming up against some resistance actually, because it isn't quite, you can take what's in the UK and implement it here, particularly as Claire's already highlighted, the challenges over, as we used to do, just rely on the ICO guidance in this part of the world. I don't think we really can anymore in the same way, particularly in Guernsey, where the changes are more significant. Now, the other particular challenge we are going to have, I think, on local implementation is there is very much the potential, I feel, for conflicts of laws coming here. We've all got, in both islands, our own specific data protection laws for both Guernsey and Jersey, and they've been essentially now been finalised since, I think, November in the case of Guernsey and January in the case of Jersey. So we've had them for a little while now. But what there is going to be potential here is because so many of the businesses here, a lot of our business is financial services sector, so funds and trusts where they are offering services into the EU. So the primary piece of legislation those businesses will look to is the domestic legislation, but there is potential, at least I can see, for instances whereby, because our wording slightly differs from GDPR, and I'll come on to some of those differences in a moment, there is a potential down the line for a conflict as to which one takes priority. Now, the one thing I just thought I'd just finish off on this section as in terms of the overview before I get into the detail is the issue of adequacy status. I think, as Robert's already alluded to, with Brexit coming for all you guys, and you'll be outside of the EU just like we are very soon, I think almost the Crown dependencies are going to serve probably as a little bit of a guinea pig for the UK, because there's very much going to be a watch and wait, I think, approach to see how we get on with issues of adequacy. And we're already coming up against some challenges in terms of trying to implement these things. So for some of our larger businesses which are headquartered in the Channel Islands, one thing that GDPR itself does not at the moment recognise is if, for example, a set of binding corporate rules for intragroup transfers where you are transferring and sharing data outside the EEA, if they were approved by a regulator in an adequacy jurisdiction. At the minute, I don't believe there's any function or ability within GDPR itself to have mutual recognition with adequacy. And so I think that's going to be one of the challenges for the UK, to actually have a look at how those sorts of things are going to develop over the coming months, because certainly adequacy, although we've had it confirmed that it will be there in May, it is going to certainly be reviewed by the Commission over the coming years. Okay, if I just move on to the next slide then. Okay, so what I want to just cover off are some of the specific quirks in this part of the world that are just, and these are by no means the only ones, but they are some of the perhaps the more unusual ones and unexpected ones. So I think a lot of you will be familiar with this new concept that there's an ability to object to processing on the grounds of legitimate interest. It's deeply embedded in GDPR. Now, whilst Jersey has very much in this field adopted word for word the GDPR approach, in that you can refuse an objection on the grounds of either public interest or compelling interest, for some reason, I'm still to determining exactly why, unfortunately, Guernsey has decided to omit the grounds for rejecting an objection on these grounds. They've omitted compelling interest. Therefore, you could only refuse an objection to processing of legitimate interest on the grounds that there is a public interest. Now, with the push that we're all experiencing to move away from consent wherever possible and use other grounds like legitimate interest, I do think this actually leaves Guernsey potentially vulnerable and businesses in Guernsey to unscrupulous litigation tactics whereby people are going to use this ability to object to actually stymie the ability of businesses to operate where there's a dispute. Another one that's particularly relevant for this part of the world, because we have a large trust industry, is there is an exemption within both Guernsey and Jersey, which is in our current legislation by way of regulation, an exemption for trustees to refuse to provide certain information to beneficiaries where there is a subject access request. Now, the basis of this exemption actually stems from our own trust law, which essentially says a beneficiary is not entitled to information about a trustee's decision-making process. And so this is a really big area. Now, there is no equivalent exemption actually in the UK, and there was a case a few years ago involving a law firm, I believe it's Taylor Westing, who was subject to a subject access request in relation to a trustee dispute and ended up having to provide a whole load of information, which, had that request been made in either Guernsey or Jersey, would not have been the case. Now, this is the one that I think particularly there is potential here for a scope of a conflict of law situation between GDPR and the local data protection legislation. So if we are getting beneficiaries who might be resident in an EU country making a subject access request, and they'll make it most probably under GDPR itself, actually when the trustee who's resident in either Guernsey or Jersey is having to deal with that request, they're going to want to try and rely on this particular exemption to prevent them having to provide all the information that they might otherwise do. It's a real thorny issue. And another one around the trustee space that we have to face is whether or not trustees can charge the trust for the cost of dealing with a request. Obviously, everyone's familiar. GDPR says that the information for a subject access request must be provided free of charge, and that wording is replicated into our legislation. The question which is going to have to be determined at some point is, yes, but can a trustee charge their costs of administering that to the trust? It is a thorny one, and I've had disputes with both UK lawyers who agree and disagree with me on this point. But I think that's absolutely right for a dispute. And the third one in this, I suppose, the trust space is particularly around many beneficiaries may not know they are actually beneficiaries of the trust. It's quite a common thing, particularly if you're dealing with minors, but also sometimes adults, that people don't want people to benefit from a trust until they're a little bit older, maybe 25, even 30. And how does that then interplay with the duty to inform in terms of privacy notices? There are arguments to be had over here. I think there is potential workaround for not providing it in terms of it actually potentially cuts across the purpose for the processing, and there are some exemptions around that. But these are the sorts of areas, I think, in the trust industry, which makes up a lot of what we do here, potentially really thorny ones. The other main part of our industry, aside from, say, the trust and the banking, is the funds industry. And I just wanted to finish off in terms of to give a little bit of anecdotal feedback as to where I see businesses, because whilst the banks, I think, are well geared up for this because they have the UK resources, the trust companies are used to dealing with this. I think there's a real issue potentially coming down the line for those people involved in particularly the fund sector, where they don't have that UK presence, and that's driving compliance. So I think that's the area for me in terms of the offshore world, whereby there is going to be a lot of work to be done over the next 2 months. We do have exactly the same implementation date at the end of May as everyone else. So I think attitudes are changing, but that to me at the moment at the moment is the one area of particular concern I have in the Channel Islands in terms of where there's a long way to go towards compliance. Okay, so thank you for that. I'll hand over to my colleague Peter Colegate now, who'll touch on matters in the British Overseas Territories.
Thank you, Richard. So just a quick canter then through what's happening in the British Overseas Territories, which, and specifically the Cayman Islands, where I'm based and practice, Bermuda and also the British Virgin Islands, the BVI. And I guess the short message is it's all change in this region as well. And just to put it in context, that need for change, that desire for comprehensive data protection legislation in these jurisdictions is coming from clients and customers who use these jurisdictions for various services, and they now largely expect that any data that's housed in those territories is protected by comprehensive legislation and backed up by robust enforcement tools. So just looking at each territory in turn, starting with Cayman. Cayman's data protection law, the DPL, was passed in March last year. It was a long time coming, in fairness, and sort of suffered 2 or 3 setbacks and failed attempts to pass since it was first circulated as a draft bill back in 2011. After that time, the drafting committee here tried, as far as possible, to track the discussions that were taking place in the EU surrounding the GDPR, with an eye to achieving adequacy status for Cayman. But the final version that was actually passed last year largely follows the current iteration of the UK's Data Protection Act pre-GDPR. But it does in fact include some sector-specific provisions which were adopted from Jersey's law and others, particularly around trustee exemptions, specifically the trustee exemption for subject access requests, which Richard just referred to. Bermuda's Personal Information Protection Act, PIPA, was passed slightly earlier, back in December 2016. And Bermuda took a more innovative approach to their drafting. They started with a blank canvas and then essentially cherry-picked those parts of other laws that best suited Bermuda's economy and its sort of main sector-specific requirements. But by chance or otherwise, the final result is a law which essentially in substance, if not in style, again, largely mirrors the UK's Data Protection Act, again pre-GDPR. So for Cayman and Bermuda, you have 2 laws which are broadly similar, both in how they're framed and also the time frame for passing and implementation. And both laws, just by way of summary, they adopt, as you'd expect, sort of Western style, well-trodden data protection principles, and they also follow the sort of standard definitions and terminology that one would expect to see for data controllers, processors, the definition of personal data, sensitive personal data, etc. And they both have similar exemptions that you would be familiar with, having seen other Western style data protection laws. The BVI is slightly behind the curve in that it doesn't at the moment have any separate data protection legislation at this time, but the government there has pledged to enact suitable legislation based on internationally recognized standards in the near future. So watch this space for that one. And I think it's fair to say that BVI is looking to Cayman and Bermuda to see how the implementation of their new laws goes ahead, and they also are looking to the GDPR. And I think there's probably a debate going on at the moment as to whether they should simply go straight to that higher standard, or adopt an approach similar to Cayman or Bermuda. So just looking at, turning to slide 6, in terms of timing, for Bermuda, PIPA is expected to come into force in December 2018, with Cayman's DPL due to follow shortly thereafter in January 2019. And both jurisdictions are currently in the process of staffing up the Information Commissioner's Office in the case of Bermuda and the Ombudsman's Office for Cayman, who will be tasked with enforcing those new laws in both jurisdictions. In terms of how they interact with the GDPR, as I said, the intention was for both laws to track the GDPR as far as possible, but that wasn't the end result, and there are inevitably, therefore, some gaps between the laws. And just some examples would be, for example, around marketing consent, where both Bermuda and Cayman adopt a sort of opt-out approach and don't require the same sort of granular opt-in consent that is now required under the GDPR. Data breach notification, there are longer periods to notify under both laws. Both laws are less prescriptive in terms of the technical and security measures that data controllers need to put in place in terms of cybersecurity and protecting their data. And there's no separate liability in either jurisdiction for data processors. The appointment of a data protection officer is mandatory in Bermuda, or will be mandatory in Bermuda, but is not required in Cayman, although that is recommended best practice. But I think it's fair to say that notwithstanding these differences, Cayman and Bermuda will shortly have the most comprehensive data protection laws, certainly in this region. And that is certainly attractive for both jurisdictions and is being used as a means of attracting clients and customers to those jurisdictions. Both laws also restrict international data transfers unless mechanisms, be they contractual mechanisms, binding corporate rules or similar, are put in place to ensure that the transferee, the recipient, processes any data it receives to a sufficiently high standard. As I said, the aim of both Cayman and Bermuda when they looked to implement these new laws was to achieve adequacy status in the eyes of the EU, and that remains the ultimate intention. So going forward, I think that, both jurisdictions are essentially adopting a watch and wait approach to see how the GDPR beds in, with a view to then adjusting local laws to meet that higher standard and close off some of the current gaps that exist between the two regimes. In terms of what's happening on the ground, for organisations that have European touchpoints or who intend or are currently offering goods or services to EU residents, those organisations are already filling those gaps themselves by adopting higher GDPR standards when they're drafting their policies and procedures. And this is also the advice we are giving to clients on the basis that, you know, local laws are likely in the not too distant future, perhaps even 2019 or shortly thereafter, to be updated to reflect those higher standards. So that's just a very short canter through what's happening in this region.
Thank you, Peter, and indeed to Richard and Claire, Katherine. We've actually got some questions come in, and Peter, one that's sort of for you and a bit for me. It says, if the UK is chosen as the lead supervisory authority under the GDPR one-stop shop, will that relationship end when the UK leaves the EU, or will an adequacy decision from the EU allow countries like Bermuda to consider using the UK? And just before I get your thoughts on that, Peter, for the person who raised the question, this is one that's coming up, at least I think we're all saying all the time. Yes, at one point, if the UK is in the EU and the supervisory authority is properly chosen as being the UK ICO, that's great. Of course, post-Brexit, unless the UK has managed to negotiate an adequacy decision at a time when it doesn't seem to me there's much being given away by the rest of EU, unless we've negotiated it, we are the same as everybody else. We don't have an adequacy decision, and indeed we're even worse than some of our dependents, because they've already got an adequacy decision that will run on. I'm assuming that the thrust of the question, Peter, is that if the Bermuda as a business is passporting data sharing through the membership of the UK in the EU, is there a challenge when we are not in the EU? Can I throw that one over to you, Peter?
You can. I'm not sure I know the answer to it, sadly. I think that's probably right. I mean, I think Bermuda and Cayman are even a step behind, perhaps, in the sense that they're looking to achieve adequacy, but they're not going to achieve it at this stage. And I don't know, and I'm not sure anyone knows how, either in the interim or even if they achieve adequacy status, how that would tie in terms of the ability to transfer data to and from. And I don't think at this stage it's really being thought about. I mean, there is definitely a sense in both jurisdictions they want to see what is going to happen. And to your point, I think part of that watch and wait approach is to see what happens with the UK, and perhaps follow that approach. So we're probably one step behind even the UK in that sense.
And I might thank you for that. And I might just add in for the person who sent the question in that for a multinational now, using the model contract clauses as a sort of framework agreement where all of the members of a banking group, for example, or a funds group sign up to it, you're either in the EU and you're a data exporter under the model clauses obligations on an exporter, or you're not in the EU and you're an importer, like the Caymans, like the UK would be once we've left. So I think that a sort of framework agreement that manages all of the global entities might still allow a transition from the nanosecond the UK's in to the nanosecond it's out, because at one point it's an exporter and at one point it's an importer, and that might be a belt and braces approach, as I might say, to put in place in anticipation of that uncertainty when you want to keep on sharing personal data, which is a matter of business. I've got another question. I'm going to throw this one over to the Isle of Man, because to some extent Richard reflected on this, but I wanted to ask Claire and Katherine, what do you think in the Isle of Man is the level of awareness and understanding of GDPR?
Thanks, Robert. I mean, I think for the large financial services businesses, institutional businesses, for our large, the Isle of Man has a large number of online gambling companies. And for those international businesses, I think there is a massive awareness. Our Information Commissioner had a large conference in the summer of last year, and there was over 300 Isle of Man attendees at that. The local Chamber of Commerce, the Institute of Directors are all doing seminars. So I think at that level, there is a very much an awareness. And as Richard said, obviously a lot of this for the larger businesses is being led by the London lawyers. So I think they're fine as much as they can be. I think the problem is for, and I'm guessing this is the same everywhere, for the smaller businesses that just don't have the resource or the money or the ability to actually make sure that everything is done by the 25th of May. So I think generally on the island, yes, there is massive awareness. The larger businesses will be fine. The smaller businesses, I think, will struggle, which I think is something, to be fair, our Information Commissioner has recognised and has, as I said, sort of through Chamber and the Institute of Directors, has targeted training specifically at that sector. But it's still an issue.
Yes, and it's interesting. Just literally in the last this week, our UK Information Commissioner has now started to put out doing advertising on local radio about her resources for small businesses, precisely because I think the regulators realise without some help, they're not going to get anywhere near to getting over the line by the 25th of May.
Yeah, I think that's right, and that's one of the messages that I think local businesses gave to the Isle of Man government. As Katherine said, our consultation period for our legislation just closed on the 5th of March, and I was involved with the Chamber of Commerce's response to that, and that was very much the feeling that we were getting from the smaller businesses. You know, was that they do need some assistance, and I think our Information Commissioner has listened to that, which is good. But also, as Katherine said, you know, his office isn't overly resourced either, so you know he has other things to deal with before the 25th of May as well.
I've got one more question, which I'm going to put to Richard before we get to the end of our allotted time. Richard, what do you think overall in the dependencies and overseas territory is likely to be the approach of the regulators when it comes to enforcement?
I think that's going to be very much down to the local, the personality involved, because they are going to have such an important role. So in Guernsey, I think as I mentioned, we've got Emma Martin, who's the previous Joint Channel Islands Commissioner. And what's great about that for Guernsey is she's a known quantity. She understands, again, as with Isle of Man, we've got a lot of small businesses here, both in the financial services and the non-financial services sector. That's where the challenge is going to be. And I think her attitude is very much about working with business, alongside business, and in partnership with business to try and get to compliance. I don't realistically think for 1 second she's going to be, come June, firing out massive fines for anybody. I would be very surprised if there's anything in the next 2 to 3 years, realistically. I think it'll be about improvement notices. Now, if I take Jersey, though, and this is one of the real concerns, is we don't know who it's going to be. We don't know where they're coming from. I think probably the educated guess is this is going to be someone who's going to come probably from the ICO in the UK. I know there aren't going to be many free data protection lawyers at the minute that aren't in employment. So I think that's where it's going to come from. And so there's going to be a real challenge for that person coming into a very different environment and trying to regulate that. So I do think there is some real challenge. But I suppose the Isle of Man, it's Claire's area, but I'm sure she won't mind me saying, the Isle of Man have got the benefit, though, of a known quantity there too. Their regulator's been in place for a good few years now. So again, I think Guernsey, Isle of Man, probably we can be pretty comfortable because we know our regulators. Jersey, who knows? Okay,
thank you, Richard. And I guess for everybody still on the webinar, the good news is that on the 26th of May, when GDPR is in, there is nothing going to happen because it's a Saturday. And in fact, it's a spring bank holiday in a lot of Europe, so nothing will happen on the Sunday or the Monday either. But yeah, I agree, at some point something will happen. The next webinar that we're doing is on April the 10th. And there again, I'm working with some legal friends in South Africa. I love the fact that we've got a law called PIPA. We've got one in South Africa called POPI. And we're going to do a comparison between GDPR, South Africa, and the Russian regime. So do look for that on our website. Do also look for the recording of this webinar, which should be up there in a few days' time. If there's any further questions, by all means forward them to us, and we can pass those out to everybody at Appleby. And I wanted, on your behalf, to thank Claire and Katherine and Richard and Peter for all of their input today, which was fascinating. You would think it's one size fits all, and it simply isn't. So from all of us to you, thank you, and we look forward to being with you on another occasion.